Good afternoon, everyone. My name is Lluc Cerda. I'm a senior associate here at Samfiru, Tumarkin. I'm the managing associate of our Calgary, Alberta office. I'm here to answer your employment law questions at our employment law Q&A. If you have any questions at all related to employment or your workplace or anything like that, feel free to put them in the chat. I'm going to try to get to as many of them as possible today. We are here to answer your questions live, as always. So we're going to get to as many of your questions as we can today. So don't hesitate, put them in the chat. I also want to let you know that we're doing this show every day this week for everyone to be able to get all their questions answered. My colleague Madalena is here tomorrow at noon Eastern time, 3 p.m. Noon Pacific time, 3 p.m. Eastern time to answer your questions. So if there's anything we can't get to today, we have someone on deck waiting to answer your questions tomorrow. All right, so we have our first questions come in. It's from YouTube, from Bill. Bill is asking, is the duty of good faith and fair dealing in the matter of dismissal of an employee still good law? All right, so that's an interesting question. What that is basically the courts, including the Supreme Court of Canada, have found that the employer, and this is for most people uncontroversial, they have to treat you with respect when they terminate you. All right. So if an employer is trying to, for instance, pressure you to quit, or is alleging just cause when there is no cause, just so that they don't pay you severance, or is unnecessarily terminate you, that allows the court to say, well, there's been a breach of the duty of good faith here. And if there is a breach of the duty of good faith on top of being awarded your severance, the courts can order that additional damages be paid to you, such as punitive damages or aggravated or moral damages. So, Bill, to answer your question, it is still good law, absolutely. The courts take a very dim view of employers, in essence, try to break down their staff psychologically to get them to quit, or who make spurious cause allegations, maybe involve the police unnecessarily. There's a lot of bad stuff that you see when you read the case law. Now, my experience is that most Canadian employers are good employers and treat their employees with respect, including when they're terminating them. But that's not necessarily the case for everyone. There are some employers out there who do try to get out of paying their severance and go to extreme lengths at times to get out of paying their severance. And the courts have said that is absolutely not acceptable. These are human beings that need to be treated with respect. So if you are trying to get rid of an employee and not treat them with respect and not give them the severance they're owed, we are damages to that employee to punish you for your behavior or to compensate them for the additional, mental aggravation that's resulted from the way that you got rid of them. Absolutely. That's still good law, Bill. Absolutely. We have another question here from Elena Combs. If an employee is being harassed at work and also followed home by a fellow employee, and you report this to human resources and they take no action, are they liable for the continuing harassment? So there's a few things to unpack in that question, Alana. So firstly, every workplace has to have a workplace violence and harassment policy. That's the case here in Alberta, in Ontario, I believe in BC as well at the federal level. So if you work for a bank or something like that. So there is a requirement that they have an anti-harassment policy. Now, those policies always have to include a mechanism by which a complaint can be investigated. All right. So yes, if the employer is not fulfilling its duty to investigate claims of harassment, there are different avenues that open up. You can make a complaint to the Labor Relations Board, or rather to an occupational health and safety inspector at the Ministry of Labor, who will force the employer to conduct that investigation. You all might also have a claim here where you're thinking, well, I cannot continue to work in a place where I'm being followed, a colleague that I don't know what their intentions are. And so that might be a situation where you're in a constructive dismissal situation where you cannot continue to work there for reasons unrelated to you, really, because you're suffering harassment. And so you would quit that job, but because you were forced to quit, you'd have a grounds to say that you're still owed severance. All right, so then there would be a claim for severance. In terms of the harassment in and of itself, so imagine a scenario you were being harassed by a neighbor or something like that, unrelated to the workplace, that is generally not recognized as something that you can sue that person for unless it becomes, all right? So you wouldn't necessarily have a claim against this other employee for harassment. That said, you would have a claim for severance if you're unable to continue to work somewhere because of the harassment. Absolutely. And if the employer has failed in their obligation to properly investigate this harassment and allowed it to fester, then we, again, to turn back to Bill's comment, we might have some damages that are awardable for the lack of fair dealing in good faith in the matter of your employment, essentially, right? I mean, you're trying to just go to work and earn your salary, and then there's all this extraneous stuff that's preventing you from doing that. It's affecting your mental health potentially, or your physical health and your sense of security. So definitely the employer might be on the hook for paying you additional damages on top of your severance for not having taken any steps to protect you. So Elena is adding that they did nothing to investigate the complaint and that she had to go to the police. Those are very serious. That seems like a very serious situation. So I mentioned constructive dismissal. Constructive dismissal requires you to say, I am not going to continue to work here. I am going to instead quit and go after my severance. So that puts you to an election. You have to decide, have things gotten so bad that I can't continue to work here? If that's the case, get in touch with us and we can talk to you about your options about going after severance. If, on the other hand, the issue has been resolved and you're happy to continue to work there, then you have to make that decision. What happens when you decide to accept this issue is that it becomes hard in the future to say, well, actually now it's not acceptable anymore. So imagine a scenario where you're being followed, just to use an example, you're being followed at home by a colleague. You report it, nothing's done. You call the police, the colleague stops. You now have a choice to claim constructive dismissal. You say, well, listen, it seems to have stopped, so I'll leave it alone. For some reason, a year down the line, you decide, well, I don't want to work here anymore. Can I rely on the fact that I was being followed a year ago to go after my severance? It might be too late at that point. If nothing new has happened, it might be too late to claim constructive dismissal. So it's important that you realize whether you want to continue to work with this colleague. And if you don't want to work with this colleague, get in touch with us. We can help you get out of there, be safe, get your severance, and move on. If, on the other hand, you're like, why should I leave? I'm not the one who did anything wrong. Then the move is to then contact the labor board, force the employer, or rather contact health and safety at the Ministry of Labor, force the employer to investigate. And if the employer is forced to investigate and finds that there's been a violation of the health and safety policy, they would then be required to provide some sort of discipline, which may include termination, which may get this harasser out of the workplace for you. So a few options that are available to you, Alina. All right, so Alina mentioned furthermore that you have spoken to an attorney. The issues seem to be hard to prove. It can be hard to prove harassment. I always tell my clients, you know how it was. You were there, the side glances, the tone, the posture, and all of that. But how do you explain that to a judge 2 years later at trial who wasn't there with you? It is challenging to prove harassment when it isn't very overt, when it isn't like basically, screaming and yelling and stuff like that. It can be hard to prove. It's not impossible to prove, though. It's a harder case than a straight wrongful dismissal case. So feel free to reach out if you want a second opinion, because although they're harder, they're not unwinnable either. And we're happy to do the work to get you what you're owed. So feel free to reach out to us. We're at employmentlawyer.ca. You'll be able to schedule a consultation with one of us here. And we'll be happy to go over it again if you want a second opinion, haven't spoken already to a lawyer. We have a question here from Sean on Facebook. Can a doctor from a walk-in clinic provide a letter for medical accommodation in the workplace? I need to go on leave for stress and anxiety, but my family doctor doesn't want to write the letter. So yes, any doctor can write you a medical note, absolutely. Will they? Well, that's up to them. So it's up to them in their professional opinion whether they think you need time off work or not. All right. So there's no way to force a doctor to give you the medical note that you want. If your family doctor isn't hearing you, isn't recognizing the distress that you're in, you have, as you've identified, some options. You can go to a different doctor or walk-in clinic. You can also visit the emergency room if you're in crisis. All right. And any doctor that sees you there that agrees with you that the workplace is the stressor that's making you sick, well, they should back that up with a doctor's note to let you go off work and get better, essentially. So yes, any doctor can write you a doctor's note, absolutely. But it's up to them to decide whether they will or not. There's no way to force them. So we have a question here from Niru. I've been offered a position by a US-based company to work remotely, but the contract says that my salary can be adjusted at a later date. Is there a limit to what this clause means? Can they choose to pay me much less than what I was offered? So it's hard to say without seeing the contract. It's hard to say without seeing the contract. It's also a U.S. contract. I guess you're working for this U.S. company from Canada. So the reality is salaries get adjusted all the time. All right. Usually upwards, of course, you get a raise, right? It can be adjusted downwards without that, triggering a constructive dismissal. We're usually talking about a change of 10 to 15% or more is going to be, in most cases, a constructive dismissal, okay? So you'll be able to say, well, I'm not accepting this, I'm quitting, and you owe me severance. There's no way to force the employer, though, to maintain your salary. So you can't say, well, listen, my salary's always been, $75,000 a year. Now you want to cut it to $65,000 a year. I don't accept that. You have to continue to employ me at $75,000. There's no court that can force the employer to do that. The only thing a court can do is say, well, this is a constructive dismissal, employer. You owe this person severance. So if it's a very new employment, it might be that you don't have a lot of severance entitlements. Of course, new employees have disproportionately more severance per year of service than longer-term employees. So it's not uncommon, for instance, for a 2-year employee to be entitled to 4 to 6 months of severance, sometimes even more, depending on how senior they are. At the end of the day, though, it's not, you're not going to get the full 24 months that is potentially out there for more senior employee, more longer service employees. So all that to say, generally it will be a constructive dismissal. Having a clause like that still requires the employer to do the pay reduction reasonably. I would try to get some language in there stating that any pay cut will be within reason, or something to that effect, to show that, listen, I'm not agreeing that you can go from paying me, say, $75,000 to $15 an hour. I'm not going to agree that you're allowed to do that. All right, that's basically a very fundamental change, and if you do that, then we're going to have a problem. All right, so you want something like that in the contract, saying, listen, you can change the compensation, but within reason only. And if it's beyond reason, then I'm not going to accept that, and you're going to owe me severance. All right, so we have a question here from Belinda Beguilin. My husband is taking a position with a local construction company, but will be working out of Saskatchewan for the next 9 months. Would he be considered to be employed in Alberta or Saskatchewan? So what I can tell you about Alberta law, I'm not an expert on Saskatchewan law, so we'd have to take a look at what their employment standards legislation says. In Alberta, essentially, at the entirety of the circumstances to determine which law applies. Is it the law of Alberta or is it the law of Saskatchewan? So some things that are relevant to that analysis will be, where were the parties residing when the contract was signed? So if the construction company has its headquarters in Alberta, if your husband lived in Alberta at the time the contract was signed, then that's an indication that the contract is governed by Alberta law. Of course, where the work is performed is also going to be a consideration, but this seems to be of a temporary nature. So unless it's a temporary contract, then that might not be all that relevant in the grand scheme of things. Is there something in the contract that says which law governs? So you can say in a contract, well, this contract will be governed by the law of Alberta or the law of Saskatchewan or whatever it is. So that's going to be a factor as well. So essentially, there's no kind of yes or no answer to this question. You have to kind of look at the totality of the facts at the time where you're invoking the law of the province in question. And usually that's at termination when you're going after severance. One thing that you should keep in mind is when you're terminated, you're owed severance. So both Alberta and Saskatchewan likely have minimum severance entitlement. They might differ between those two provinces. However, you have an overarching right to what's called full severance, all right? And that full severance really is pretty much the same from province to province. So unless your husband signed a contract that said, well, if I'm terminated, I only get the minimum, that's employment standards laws, then your husband will be entitled to full severance. And like I said, at that point, it really just becomes, well, where do we start the lawsuit if we have to start one, in Saskatchewan or in Alberta? It probably would be more convenient if he's back in Alberta at that time to start in Alberta, and that's another argument in favor of it being governed by the laws of Alberta. So all that to say, it's, as lawyers tend to do, it depends. It's complicated. I'd have to see the contract and hear a little bit more about what the situation is. So there's no clear-cut answer in our employment standards legislation as to what law applies if for out-of-province work. Kashina Pefgrave asks, I just received a letter from my employer, asking I seek Canadian pension disability benefits after 26 weeks. All right, so my understanding of that question, Kishana, is that you're on some sort of medical leave right now because of a disability. I'm not sure exactly if you have through work, you have long-term disability protection. So if you do, you should apply for Canadian Pension Plan Disability. That's an option that's available to you to receive additional funds for your disability leave. It might be that your insurance provider, your LTD insurance provider, will also require you to do this, because that means that the Canadian government pays for a portion of your disability benefits, which reduces how much the LTD provider has to pay. That said, I gotta say, I'm not really an expert on disability law. I practice mainly in employment law. We do have a disability law group here at the firm, and they also have disability law Q&As, just like this one. So my producer will put up on the screen shortly when the next disability law Q&A is happening. I invite you to jump on at that time, see if they can answer your questions related to whether you should or shouldn't apply for a CPP disability. But they'll be able to help you navigate that process so that you can get the everything you're entitled to while you're on leave. We have another question here from Pete from Facebook. My boss recently moved his company to Edmonton from Calgary. I've worked there for 16 years. Do I have to move to the new location? It's very far for me to commute. I can imagine that, yes, if you live in Calgary, having to commute every day to Edmonton is just not realistic. So no, you do not have to move, all right? Here are your options. You can ask your employer if you can work remotely from Calgary. But if not, if the employer insists that you have to go on site in Edmonton, then you have the option to say, well, this is a fundamental change to my employment agreement, all right? I started working for you 16 years ago when you were in Calgary and I was in Calgary. You can't just pick up and move and expect me to follow you everywhere you go. So I'm not accepting this change. What that means is that I am not going to move with you to Edmonton. I am instead going to quit and find a new job. You forced me to quit by moving to Edmonton. You now owe me a severance package. Okay. So you have a few decisions you have to make now, Pete. You have to offer to your employer the option of continuing to work from Calgary in a remote capacity. If you do, then make that offer. If the employer refuses to allow you to work remotely, then you have to decide, do I want to move myself and my family to Edmonton to continue to have a job? Or do I want to quit and go after my severance? If you decide that you want to quit and go after your severance, then contact us. We can help you get that severance. All right. Again, if you decide to move to Edmonton, move there, get there, don't really like it, it's going to be tough for you, though, to claim at that point, well, you moved to Edmonton, I followed you, I don't like it here, I'm going to go back to Calgary and you owe me severance. So you've got to kind of make up your mind now, okay, or within the next few days of what you want to do. All right. So do you know, it's an uncomfortable position to be in. It's a big decision you have to make. I think both options that you're looking at are probably far from ideal for you. It's the way it is. We have to make a decision now. They've made decisions without consulting you. Now you have to decide how this impacts you. All right. And in terms of severance, you know, I've been talking a lot about severance. What everyone needs to know is severance is different for each one of you. All right. Each one of you have different situations in terms of the positions you hold, the salaries you make, the years you've spent with the company, your current age. All these factors play a role in determining how much severance you're entitled to. So you might be asking, well, how can I know how much severance I'm entitled to? You're telling me to quit my job and go after my severance. I have no idea what that is. Well, we make it easy for you. All right. You can find out how much severance you're owed by visiting our website, and we have it here on the screen, pocketemploymentlawyer.ca. You answer 4 easy questions with no obligation. We'll tell you what we estimate your severance entitlements are. So that allows you to know what exactly you're looking at. So going after severance is an important financial decision, and you should have some idea of what you're going after. Usually they're not small amounts, all right? So it's important that you consider everything that's happening. So for instance, in your case, Pete, you know, you might be giving up a job that you've been at for 16 years that you've shown a lot of loyalty to. There's potentially a large sum of money to compensate you for having to quit that job and trying to find a new job. So visit the site, pocketemploymentlawyer.ca, answer those 4 easy questions. Like I said, no obligations, completely anonymous. If after you found out what your severance entitlements are, then you want to book a consultation with us, then you can. There's no obligation. If you just want to have an idea of what you might be entitled to, just out of curiosity, or a friend wants to know or something like that, go ahead, not a problem. We're here to let employees know what their rights are. That's what's most important to us, because when all employees know their rights, then it helps everyone else rise up together. So those are the tools you have to know a little bit what your employment rights are. All right. Now, a subject that's been in the news, I don't know if a lot of you have been following this, but something I'm seeing a lot in the news that I read is the concept of quiet quitting. So it's been a bit of a buzzword in the last 2-3 weeks, and quiet quitting refers to people who, in the unionized context, we call it work to rule. All right. So basically, it's where you stop going above and beyond at work. All right. So quiet quitting are people that will just stick to the very 4 corners of their job description, not look for any, stretch assignments, turn down any assignment that doesn't fit into their job description, who will clock out, right at 5, right when their day ends, who won't do any additional work, won't look at emails, after hours or anything like that. You have me from 9 to 5 to do these tasks. That's what you're paying me for. That's what I'm going to do. I'm not going to do anything else on top of that, because you aren't compensating for me for that. And, that was not the agreement that we had. Question you might have is, can I be terminated for quiet quitting at work? So I'll leave it up to everyone individually to decide whether that's something they want to do, whether they want to kind of, wrestle back some work-life balance or whatever it is, the reasons why people do this. But can you be terminated for it? So the short answer is you can be terminated for anything, basically. All right. You can be terminated for anything except for discriminatory reasons under health human rights, or in reprisal for having tried to enforce your rights, either under human rights, employment standards, occupational health and safety. Those are the only times that an employer can't just show you the door. However, in most cases, even though the employer can terminate you, doesn't mean they can do it for a cause. Doesn't mean they can do it for free. All right. It means they can terminate you, but they have to provide you with severance. So if an employer is like, okay, this person is not pulling their weight, we're gonna change directions here. That's fine. They're allowed to do that. Here's your termination letter, but I've been with you for how long? This is the position I had. This is what I'm entitled to in terms of severance. You need to provide me with that. All right. So in essence, it's kind of a way that certain employees who basically are unhappy at work manifest to their employer that, listen, I'm not going to quit because I need this job, I need a salary. But if you terminate me, then I'm owed severance, right? So if you pull the trigger on me, then you have to pay me with severance, all right? So those are kind of the basically, there's no way you could really be terminated for cause for doing your job. Right? If you're just doing your job as your job was described to you as being when you were hired, you haven't done anything wrong there. So if you haven't done anything wrong, then there's no cause to terminate you. All right. You always have the right to have a judge decide whether the employer had just cause to terminate you. I see it a lot every day. An employer will say, well, I had just cause to terminate you. I don't want you to think that that's written in stone, that just because the employer says it, that that's the truth. You can have that decision to terminate you with no severance overturned by a judge. And if a judge agrees with you that you didn't do anything wrong, or whatever you did was not so serious that the employer could terminate you for cause, a judge is going to award you severance. In fact, most of the time, this doesn't even make it to a judge, because basically once the lawyer is involved, the employer realizes, okay, well, the gig is up. I do what I'm supposed to do, which is pay severance. All right. So it's unfortunate that we live in a world sometimes that you have to hire a lawyer to enforce your right. It's the reality we live in. It's not going to change. So if you're struggling to get your employer to do the right thing, to treat you according to your rights under employment law, that's why we're here. We're here to speak with you, help you navigate that process, get you what you're owed, so that you can move on, with the protection of your severance to help you find hopefully a place that you're going to be a bit happier at, and it'll treat you a little bit better. All right. So as I said at the start of the show, we have more shows like this coming up all week. My colleague Madalena is here tomorrow. Hold on a second. I've just been informed that there's a lot of questions left here. There was a problem with my feed. I wasn't scrolling. Let me get through some of these here. Sorry about that. Okay. Carolina, a gold girl, asked me, how is it legal for a company to keep your personal property belongings after termination if they refuse you getting it the day of termination? Well, it's not, Carolina. It's not legal. It's your property. You get to have it. All right. The issue some employers might have is letting you back onto their property to collect your belongings. If that's the case, then they should just put everything in a box and ship it to you. All right. So it's your property. Let them know that you want it back. Doesn't mean that you can force them to let you back on site to pick it up. But if they don't want to let you back on site, then tell them to mail it to you, to courier it to you, so you have it. It's your property, so you're entitled to it. And because it's property, if things really get out of hand, you can have the police get involved and get you your property back. All right, this is your stuff. I have the same thing happen on the other side of things. I have employees who are terminated for whatever reason, and they have a work laptop, they have a work cell phone or something like that. I tell them, listen, this is not your property. The police the employer could potentially call the police to have you return that. All right, so just do it. Just return it. Don't get the police involved. But it goes both ways. If it's your property, if you have whatever it is at work, it's yours. That's not theirs, right? So they have to give it back to you. Now, if they haven't terminated you, if they have terminated you, Carolina, which I'm seeing here, they provided you with no severance, that is potentially illegal. All right. So I'd have to see a little bit why you were terminated, what the termination letter said. But the default is if you're terminated on a without cause basis for lack of work, whatever it is, restructuring, anything like that, you're owed severance. All right. There's no way you're not owed something unless you're really in your probationary period. And even then. So get in touch with us. We're happy to discuss what's going on so that you have a better idea. All right. Well, I see here Carolina said that someone is going to bring it to you. So that's the requirement, that they return it to you. It's not necessarily that you're allowed to go onto the premises to pick it up. That said, make sure that everything's in there, and then let them know if anything is missing. I have a question here from Julie Johnstone. Can my employer change the way I'm paid? I'm salaried and the company wants to pay us hourly. So again, this goes back to, well, how much of a change is it? All right. So any change that is non-fundamental is theoretically allowed. All right. So for instance, if you were paid twice a week before, and now they want to pay you once a month, if that's not a fundamental change, if you can't convince a judge that's a fundamental change, there's not much you can do about it. That said, if it is a fundamental change, then you can quit and go after your severance, claiming constructive dismissal. So when you switch from salary to hourly, it could potentially be a claim for constructive dismissal, especially because, if for some reason they don't have work for you, they send you home, they're only going to pay you for the hours that you worked. If that's enough hours, right, then that can result in a substantial reduction in pay. So if that's your fear, or if that fear is being borne out because you're being your hours are being cut and all of that, then yes, that can amount to a constructive dismissal. So it really depends on each and every situation. Just switching from salary to hourly, if there's no risk that you're going to lose hours, I don't think would be enough. But if there's a risk that there's hours that you will lose that you won't be paid for, then that could amount to a constructive dismissal. So Kishena Pefgrave, who was asking us earlier about applying for CPP disability, is telling us now that she's in a unionized environment. So usually unions might have LTD. So it might be your union or your LTD provider that's asking you to apply for CPP, which is, I think, normal. As I said, you can jump on our disability show to ask them. But the reason they're doing it is because that means the LTD provider has to pay less, because they'll continue to pay you what you're getting every month, but part of that will be coming from CPP disability instead of coming straight from the insurer. It's my understanding is very common, but if you jump on our disability show, I'm sure my more experienced colleagues in the matter will be able to answer your questions with regards to that. You should also have probably some help from your union, so feel free to reach out to your union. See if they have anyone that can help you with, this process, be it applications or whatever it is. So there might be someone there that can help you. We have a question here from Kathy on Facebook. What would qualify as workplace harassment or bullying? All right. So I'm not going to give specific examples, but there is generally in these policies, there's a definition of what workplace harassment is. All right. So workplace harassment is a course of conduct which is known, or should likely be known, to be unwelcome. Okay. So basically, if someone is doing something that they should know you're not okay with, that's enough for harassment. All right. So it could be very small things. Some people, you hear about it in the news, some people are very kind of what they call touchy, in the sense that they'll hug a lot, they'll put their hands on your shoulder and all of that. If you're okay with that, there's nothing that's not harassment. But if that's something that makes you uncomfortable, if you feel like your boundaries are not being respected, then that can amount to harassment. All right. So the process then is probably a lot of policies would tell you to address it directly with the person. Tell them, listen, I don't like it when you touch me at all. Don't touch me. That's fine to say. If you don't feel comfortable doing that, I would say that doesn't mean that you don't have recourses. You can go to your HR department, tell them, listen, there's a situation, it's getting out of hand, it's getting worse, whatever it is. Here's the details. Do something about it. You're always allowed to do that. All right. So feel free to do that. All right, so I have Belinda thanking us. Thank you for joining the show, Belinda, and hope everything we told you has helped. Carolina is also thanking us. Apparently, yes, the objects are coming back through a moving company. It's taking a bit of time. Feel free to jump back in next week if it still hasn't followed through. But like I said, your ultimate option is to call the police. All right, this is your stuff. You're entitled to have it. And Julie Johnstone is also thanking us. Well, thank you all for joining the show. It was really a pleasure to speak to all of you today and answering your questions. As I said, we're back tomorrow with my colleague Madalena. She's on at 12 p.m. Pacific, 3 p.m. Eastern. Feel free to jump on if there's any additional questions that you want to ask. And my name is Lluc Cerda. I'm a senior associate here at Samfiru Tumarkin. I'm the managing associate of our Calgary office. Signing off from beautiful Calgary. It's a nice sunny day. Hope it is where you are as well. And we will see you soon. Take care.